You know what really grinds my gears?
What?
The media says so-and-so faces up to 11 billion years in prison.
11?
And while that's theoretically possible,
Counts 1 through 31 charge Trump with willfully retaining national defense information in violation of 18 U.S.C. 793E, which is the Espionage Act.
Is it an
Counts
Excel
1 through 21
spreadsheet?
relate to documents that were obtained. If you were to take this case to trial and be found guilty of
Oh,
all counts 1 through 36, what kind of sentence would he receive? What's at stake here? Now, you'll
What's at
remember in
stake?
our
That's
George
what I'm
Santos
asking.
video, I took a quick little dive into the federal sentencing guidelines.
Oh my
Now we're
god.
going to take it to 11. This is going to be fun, but I'm also going to tell you this. This is the only time we're doing it. In any future video where we're going to talk about the federal sentencing guidelines,
Come on, nerd
we're just gonna
out.
put up a
Stop with the
little
disclaimer.
thumbnail.
Just nerd out, bro.
I'm just not
Just
doing this.
nerd the
In
fuck out,
1984, the United
please.
States Congress overwhelmingly passed the Sentencing Reform Act.
Okay.
The Sentencing Reform Act did a couple different things, including eliminating federal parole. But most importantly for our purposes, it established the United States Sentencing Commission.
Okay.
That commission was
This is so
tasked with
fucking
the
boring.
sentencing guidelines.
Please get to the
The basic
juice.
policy behind the sentencing guidelines with the elimination of federal parole. A person sentenced to prison serves that sentence, minus maybe 15% for good behavior. Reasonable uniformity and proportionality, however, are a little bit more difficult, and there's sometimes
You ever wonder, like, man, I wish I could be a lawyer as a kid, right? You ever wonder, like, man, I'm glad I didn't do that, man. That, holy moly, dude.
in tension with one another. The sentencing guidelines can't take into account. So in addition to creating a framework for treating similarly situated defendants similarly, the guidelines allowed for departures from the guidelines under certain circumstances. In other words, the guidelines maintained a limited amount of discretion for judges. The sentencing guidelines rely on something called the sentencing table. The vertical axis tracks the seriousness of the offense.
That's
An offense
very
level
serious.
of 1 results in a much lower sentence than an offense level of 28. The horizontal axis tracks the criminal history of the defendant. The greater the criminal history, the greater the sentence. So a defendant with no criminal history who commits a crime with an offense level of 17 has a guidelines range of 24 to 30 months in prison. If only it were that simple. Each crime has a base offense level and then potentially a bunch of adjustments up or down from that base offense level. It gets even more complicated when the defendant is convicted of multiple crimes. Consult the grounds for departure provided in the policy statements of the sentencing guidelines.
Yeah, oh, it's in the
And
way of his
third,
face.
apply the factors contained in 18 U.S.C. section 3553A. So what are those factors?
Those
I mean,
factors,
they're pretty
yeah.
generic. Look at the nature and circumstances of the crime and the characteristics of the defendant. Consider how the sentence will impose a just punishment, deter other criminal conduct, protect the public, and potentially reform the defendant. They have their own little two-step dance to do. The first step is to ensure that the district court committed no significant procedural error, such as improperly calculating the guidelines range. The second step is to consider the substantive reasonableness of the sentence itself, taking into account the totality of the circumstances, including the extent of any variance from the guidelines range. Because while this crime does come up, it's not as common as, say, robbery. There are two sections of the guidelines that seem like they could apply. 2M 3.2 and 2M 3.3.
Oh,
I'm just going to
that's
call
my
those
favorite
sections
number.
2 and 3, just to make things easy. Plenty of
Yeah.
commentators have used Section 2, probably because its title in the guidelines is Gathering National Defense Information, while
Yep.
Section 3's title refers to transmitting and decision-making when it came to the retention of the classified document. As such, he gets a 2-point increase from the base offense level. Now, if the criminal activity involved 5 or more participants, well, NAUDA, employee number 2, and attorney.
Yeah, employee number 2.
The problem is that a participant
Fuck.
is defined as someone also formally increased for a general leadership role.
Come on.
And believe me, it's not going to make that much of a difference later on. The second adjustment is for abuse of the position of trust. Trump can get another 2-point increase if he abused a position of
Fucking
public
carrots,
trust
dude.
in a manner that significantly facilitated the commission or concealment of the offense.
Shit.
No-brainer, and it's frequently applied in these kinds of cases. After all,
Man.
virtually
Yeah, we
all
should go back
people
to the video.
charged with willfully retaining national defense information had a right to access that national defense information at some point. They had clearance and need to know, which arguably really only comes from a defense level of 30. That's a base offense level of 24, plus 2 for the leadership role, plus 2 for the abuse of public trust, and plus 2
Yep.
for obstruction.
Mm-hmm.
If we